Hello, and thank you for joining today's webinar, US, UK, and EU Trade Sanctions Global Overview of Sanctions Programs and Their Practical Implications for Business. We have a wonderful program in store for you today. Before we begin, we have a few housekeeping items. Today's webinar will be recorded and circulated to all participants after the event. Additionally, should you have any questions that you would like to submit to the panel, you may submit them through the chat box at the bottom of your screen. With that, I would now like to turn things over to the Chair of Dentons Federal Regulatory and Compliance Practice, Mike Zolance. Over to you, Mike.
Well, greetings to everyone who is in the process of joining or who has already joined. As Maddie mentioned, my name is Mike Zolance, and I head up our Federal Regulatory and Compliance Practice in the U.S. And serve as the D.C. Office Managing Partner. In both of those roles, spend a lot of time on trade and trade compliance issues. I'm very excited to be joined by many of my colleagues today and tomorrow, both here in the U.S. and globally. We're going to be providing an overview of a whole range of sanctions topics, staying current, staying focused on business implications for those sanctions programs, and offering over the next 2 days a comparison of how the US, UK, and EU handle these issues. Today's program is largely US centric, although we will talk a little bit about how the US sanctions programs have an impact globally on business and how they may differ in some respects from other mechanics of sanctions programs in other geographies. But it is a very comprehensive and I think on some level exciting program. We will take you around the globe, or at least the sanctioned parts of the globe. And we are very, very pleased to be able to offer this in cooperation with ILI. So without any further delay or ado, I will turn it over to my colleague and partner, Peter Feldman, to start through the US sanctions. And I will be back with you at other points in the program to talk more specifically about some of the sanctions programs we're covering today. But with that, Peter, over to you.
All right, well, thank you very much, Mike, and good morning, good afternoon, and good evening to everyone joining in the US and around the world. It's really a pleasure to be with everybody today. And as Mike has kindly noted, my name is Peter Feldman. I'm a partner in Dentons' Washington, D.C. office, and I help clients understand and comply with and deal with US sanctions and export controls as they do business all around the world. And if we could advance to the next slide, please. We're going to start today by setting the table with some of the fundamentals of US sanctions, and then turn a bit later on to some of the major US sanctions programs that are in the news every day, in boardrooms and in term sheets, and that tend to come up in business deals increasingly of late. So let's go to the next slide, please. And in this opening section, we're going to answer the question of what do you talk about when you talk about US sanctions? And I'm going to take you on a very quick journey through a few hundred years of history, quite a bit of law and policy, and a good bit of vocabulary. And we're going to focus in this opening section on three key questions. Where do sanctions come from? Why are they used? And what are the key terms? And after this, my colleagues and I will then talk about some of the most commercially significant and cutting-edge sanctions programs and the issues that those programs raise for businesses, for companies all around the world on a daily basis. Now, before we can talk about where sanctions come from, we need to be clear, what are sanctions? And this is a term we see in financing agreements. We see it in contracts and term sheets of all sizes and stripes. We see it in the news. We hear about it in the political arena. And we see it in enforcement actions and prosecutions. Now, unhelpfully, the dictionary sends us in two opposite directions. And that's because, of course, the dictionary definition of sanction means both to approve something and to disapprove or punish something. So for our purposes, I'm going to talk about sanctions as being laws and regulations that restrict with whom or where and how people and companies can do business. Now, sometimes these are called embargoes, sometimes they're called blacklists, sometimes other terms are used. And as sanctions have become more frequently used and penalties for sanctions violations have become more substantial, we often see sanctions in the news and we see them described using these sort of different turns of phrase. But our focus today is going to be on sanctions that restrict business dealings using a general sense of the term. Now, sanctions for our purposes today are going to be presented from a bit of a US lens, but as Mike rightly noted, tomorrow our colleagues and partners are going to present sanctions with more of a European and UK perspective. And that's important because sanctions are not just a US thing, and sanctions are not just a national level thing. There are various different authorities that can and do issue sanctions laws and regulations, including the United Nations, the European Union, and of course, individual countries such as the United States. And while the US is maybe best known for imposing sanctions, it's also important to flag that sanctions don't just apply in the United States. They can apply globally, especially if there are certain types of connections to the United States, such as if the US financial system is involved or US origin items are involved. And sanctions are not just about who you can buy from or sell to. Sanctions are about who you can sign contracts with, who you can borrow money from, and what you can do with it. And sanctions are increasingly a risk consideration across the ecosystem of a business, from supply chains to distribution networks and all points in between. And while we won't focus so much on it today, to be clear, compliance with sanctions really is critical. And it's critical because violating sanctions can have severe consequences, severe legal consequences, severe reputational consequences. And as we've seen in recent years, there have been a series of these blockbuster sanctions enforcement actions involving banks. And in a sense, there's a natural logic to this. Banks are among the gatekeepers of the economy, and anything that banks do or choose not to do will almost certainly have a much wider commercial impact. But over the last 5 or 6 years, we've seen something that's really interesting and important, and that is the move away from sanctions being just an issue for the banks to sanctions being an issue for corporates of all sizes and stripes. And we've also seen a move towards sanctions being enforced not just against companies, but also against individuals. And it's not just about people going to Cuba on vacation anymore. Sanctions are also increasingly relevant for executives of banks, executives of corporates outside of the Cuba context, and in contexts that look much more like what we would all probably think of as day-to-day commercial activity. Next slide, please. So let's dive in on where do sanctions come from? And the answer here is in 2 parts. The first part is historical, and the second part is as a matter of law. And I want to set the scene. I want to talk about the history first, because what I think is so interesting is that sanctions today are in the news on a daily basis. But sanctions conceptually, sanctions in practice, are not a new idea. And in fact, the use of sanctions or trade embargoes or trade controls actually dates back to the founding of the United States. And if you look over that period of time, the use of sanctions has been a consistent component of US policy, US national security policy, and US foreign policy since that time. Now, to be clear, the forms have changed, the uses have changed, the impact of sanctions by the United States certainly has changed, especially as the US financial system and US dollar have become so central to international trade and commercial flows. But the examples are there throughout. The United States imposed sanctions on Great Britain prior to the War of 1812. The Union imposed sanctions on the Confederacy during the American Civil War. And interestingly enough, this actually included one of the first, as far as we're aware, licensing regimes. Sanctions were used as a policy tool by the United States in World War I, and I'll talk in a minute about how the statute that set up those sanctions is actually still on the books and still used today, almost 100 years later. But the modern era of sanctions, if you will, really started in about 1940, when the United States established the Office of Foreign Funds Control in the Treasury Department. And this was a program, this was an agency that was administered throughout World War II. And the initial purpose was to prevent the Nazis from using occupied countries' holdings of foreign exchange for their own benefit. And then when the US formally entered World War II, the Office of Foreign Funds Control played a key role in economic warfare against the Axis powers by blocking assets and prohibiting trade. So as you can see, whether it was 160 years ago with blocking and licensing, 100 years ago with declaring enemy states and restricting trade with them, or 80 years ago with these sort of dual goals of protecting assets from misappropriation and depriving enemies of economic power, the foundation of modern sanctions really goes back a long way. But today, our story really starts in 1950 with the Korean War, because that's when President Harry Truman declared a national emergency, blocked all Chinese and North Korean assets that were subject to U.S. jurisdiction, and created the entity that we know today as the Office of Foreign Assets Controller, OFAC. And today it is OFAC within the Treasury Department which administers U.S. sanctions programs. Now, it's important to note that OFAC is not the sole U.S. sanctions authority or the sole U.S. authority that can regulate trade. The State Department has sanctions powers, typically in the energy sector. The Commerce Department has export controls, which are very similar but distinct from sanctions. And other U.S. agencies may have their own types of trade controls, like in the nuclear space or with defense articles and defense services. And it's also important to note that OFAC's jurisdiction is very wide, but it's not all encompassing. OFAC does not have the authority to bring criminal prosecutions, even of sanctions matters. Those can only be done by the U.S. Department of Justice. Next slide, please. So I mentioned a few minutes ago that I wanted to sort of start with the history and then focus on the law. This is the law. And in the modern era, U.S. sanctions are derivative from both the U.S. Constitution and several bedrock statutes. Now, increasingly in recent years, we've also seen quite a bit of subject-specific legislation that's layered on top of this. And that trend really started about 10 years ago. But let's start where it all starts, which is the Constitution. And the constitutional authority for sanctions comes from both Article 2, Section 3, where the Constitution says that the executive shall take care that the laws be faithfully executed, and Article 1, Section 8, which sets out Congress's powers regarding foreign commerce. And on top of this constitutional foundation, on top of this constitutional bedrock of the pyramid, are three very significant laws, one of which, the Trading with the Enemy Act, actually dates back over 100 years. This is a World War I era authorization, and it uses World War I era types of language. It sets up an ability for the president to designate enemy states, and then regulate trade involving them. Now, the Trading with the Enemy Act, or TWIA, it's important because of its longevity. It's important because of its historical significance as one of the bedrocks of sanctions law. But today, in 2020, there's really only one U.S. sanctions program for which the Trading with the Enemy Act serves as the underlying authority, and that is the long-standing U.S. embargo on Cuba. The second of the bedrock statutes is the United Nations Participation Act. And this statute authorizes the President of the United States to impose sanctions under U.S. law when sanctions are mandated by the UN Security Council pursuant to Article 41 of the UN Charter. So the United Nations Participation Act is very important because this formalizes the legal linkage between actions taken by the UN Security Council when it comes to sanctions and sanctions as are implemented by the United States. The next statute, and the third of the big three, is IEPA, the International Emergency Economic Powers Act. And IEPA was enacted back in 1977 to more clearly define the president's authorities to regulate trade, with the idea being that IEPA is designed for situations other than wartime. So if you think about it in a sense, IEPA is a modernization in part, an expansion in part, of the Trading with the Enemy Act from back in 1917. The basic model under IEPA is that the president can declare a national emergency, and then to address that national emergency, the president has the powers to, among other things, freeze assets, prohibit transactions, set up a licensing regime. Now, these are the bedrock, but as I mentioned, about 10 years ago, the Congress started to become especially active in a bipartisan way, and what I would say is a uniquely bipartisan way, in enacting additional, more specific sanctions legislation. And this really started in earnest with CISADA, the Comprehensive Iran Sanctions Accountability and Divestment Act, and a range of statutes that followed. And I'm going to mention two in particular, and my colleagues will certainly talk more about them as the morning goes on. The first is from 2017, the Countering America's Adversaries Through Sanctions Act, or CATSA. And this laid the foundation for some really expansive and commercially vexing sanctions, secondary sanctions targeting Russia. And the second is the use in recent years of the annual National Defense Authorization Acts as a vehicle to impose sanctions. We saw this really significantly in fiscal year 2012, and we're actually seeing it today. More about those later, though. Next slide, please. Now, why are sanctions used? Well, sanctions are not just about punishment. Sanctions are legal instruments of foreign policy and national security. And in that sense, they're inherently political and policy driven, even though they certainly are matters of law, and they can be legalistic at times. And we'll talk about that legalistic nature shortly and certainly throughout the day today. Sanctions are intended to change behavior. It's not just about punishment. It's about coercion. It's about deterrence. It's about course correction. It's about using economic pressure on governments, on entities, on individuals, and leveraging that pressure, leveraging the power and breadth of the US financial system to advance US policy goals. And this is why sanctions can be so impactful. And it's also why they can be imposed suddenly without warning and can be lifted quickly sometimes. Now, a really interesting example of this dynamic occurred last year. On October 14th of 2019, President Trump issued an executive order authorizing some really far-reaching sanctions against Turkey in connection with Turkey's military operations in northeastern Syria. And on October 14th, the president he imposed sanctions on several Turkish ministries and 3 Turkish senior government officials. But just 9 days later, the president lifted those sanctions in response to a ceasefire agreement that had been reached in Syria. And that 9-day time period, that swing from nothing to sanctions, back to those sanctions being lifted, is illustrative of how these legal and legalistic measures really are tools of politics and policy. Next slide, please. Now, of course, any discussion about the purpose of sanctions also has to talk about why they matter. How do they achieve that purpose? The United States maintains a particularly aggressive system of oversight and enforcement when it comes to US sanctions. Last year, 2019 alone, OFAC, the authority that enforces the sanctions, collected more than $1.29 billion in fines and penalties. This is from companies in the US and outside the US for violations of sanctions. This doesn't count the cost of compliance, doesn't count the costs of any criminal fines, criminal matters, criminal prosecutions. These are big numbers. And US sanctions also have a significant impact because they've got a very broad reach. US citizens, green card holders are always required to comply with sanctions, even outside the US, even when they're working for foreign companies. And similarly, anyone who is in the United States is required to comply with sanctions while they're here. This means foreign or non-US nationals here on vacation, here for work. People coming to go to Disneyland. While they're at Disneyland, they're subject to compliance with US sanctions. And increasingly in recent years, we've seen that the US has really asserted a far extraterritorial reach for its sanctions. We've seen enforcement actions, we've seen advisories about transactions that occur wholly outside the physical territory of the United States. This includes transactions that clear through the US financial system, like many, but not necessarily all transactions involving US dollars. This also includes transactions involving items that might originate in the US and any foreign-made items that incorporate US content, regardless of where those items are located. And US sanctions also reach conduct that touches the United States, even in ways that I think most of us in the ordinary sense wouldn't consider to really involve the United States in a significant way. So we've seen actions, we've seen advisories, we've seen guidance that sending emails or text messages and making phone calls to, through, or from the United States using US-based servers may be sufficient. One of the other things that makes sanctions so impactful is the standard for liability. And for American citizens, for US green card holders, it's often a standard of strict liability. And what this means is Whether you or the company involved knows an activity or conduct violates the law, or should know, it doesn't really matter. You're subject to potential penalties, even if you believe your actions were completely lawful. Intent doesn't matter. Now, as I mentioned before, and I'll note again here to just sort of round out the point, compliance with sanctions really is critical. And because there's an increasing recognition, not just in the United States, but around the world, of why compliance matters, it's had a sort of self-reinforcing effect. And due to the wide reach of US sanctions, what we've seen is that business counterparties, especially banks and other financial institutions, other financial services businesses like insurers and reinsurers, they're really on high alert when it comes to whether a transaction or a customer might expose them to sanctions risk. And as a result, what we've seen over the last several years is a theme of de-risking, of people, of entities, institutions choosing to walk away from deals or transactions that they otherwise might be able to participate in meaningfully and lawfully. But if they simply can't determine with a sufficient degree of confidence that the deal is compliant, that the counterparty is kosher. And as a result of all these factors, of this aggressive enforcement environment, of the broad reach, of the strict liability for sanctions, and the heightened anxiety in the markets about the potential for risk, we've seen some really significant reputational risks factor in to companies and investors all around the world when they think about sanctions. And I'd be remiss if I didn't note that one of the most important reasons why compliance with sanctions matters is because it's now often corporate policy. It's now often a term in financing. And so whether it's as a matter of law, as a matter of contract, or just because of the risk factors, the impact of US sanctions has been magnified and is increasingly recognized in the market. Let's go to the next slide, please. Now, when we talk about sanctions, and my colleagues will shortly guide us through some of the highlights of US sanctions programs, as they do that, and throughout our discussions today, we're going to talk about some key terms, some key concepts that are common across sanctions programs. The first is the types of sanctions that we've got. And depending on how you want to count it, we've either got 3 or 4 types of sanctions. I prefer 4. I think it's sort of clearer and cleaner. Now, these include comprehensive, or really sort of country or jurisdiction level sanctions. They include list-based sanctions, sectoral sanctions, and secondary or extraterritorial sanctions. Now, comprehensive sanctions or country sanctions, these are what you think of as the embargo. So when you think of sanctions, most people think of Cuba and Iran, and that is exactly the bucket that we've got in mind here. So these types of comprehensive sanctions generally prohibit exports to and imports from and business involving a set of targeted jurisdictions. The list today is Cuba, Iran, North Korea, Syria, and Crimea. The list a few years ago included other countries, Sudan most recently. The next category is list-based designations, and these are much more narrowly tailored than the comprehensive sanctions. List-based designations, list-based programs prohibit transactions with certain individuals, certain entities, certain vessels and aircraft that OFAC has designated for one or more of a number of reasons, like being involved in drug trafficking, or human rights abuses, corruption. And interestingly, though, these list-based designations are not so surgical, they're not so precise that they don't also capture a pretty wide range of entities and individuals. That's because in some cases, a criteria for designation is being an official or a senior official or a state-owned entity of a set of governments. So for example, there are list-based designation authorities targeting Nicaragua. Well, one of the ways in which those authorities can be imposed is by being an official of the government of Nicaragua. Now, collectively, the total number of designations on these list-based programs is significant, well into the thousands. And what it means to be a list-based designated person is that all of your assets and interests in property or interests in assets that are within U.S. jurisdiction are automatically blocked. They're frozen by operation of law, and U.S. persons are generally prohibited from dealing with SDNs. So if you are designated, if you are subject of a list-based designation, the United States all of a sudden essentially becomes off limits. And anything that you've got in the United States, even if it's just sort of passing through, is frozen automatically. In addition to the list-based designations and the comprehensive sanctions, we've also got a sort of newer creation of U.S. sanctions, which are the so-called sectoral sanctions. And these sectoral sanctions are comprehensive in the sense that they apply with respect to certain countries, and list-based in the sense that they don't cover absolutely everything. They only cover certain individuals and entities. But they're even a little bit tighter than that, because they don't prohibit everything with the country or everything with an individual designee. They just prohibit certain things. So sectoral sanctions prohibit certain types of financing and commercial terms, including things like payment terms. So how long is a vendor who is subject to sectoral sanctions allowed to pay an invoice? That is something that's within the sectoral sanctions. And currently, the United States imposes these sectoral sanctions on a number of companies from Russia. So in the banking sector, in the energy sector, in the defense sector, and their subsidiaries. Now, unlike people on the SDN lists that I've just mentioned, again, sectoral sanctions are not a comprehensive blacklist. Not everything is blocked for all times and all purposes, and not all transactions are prohibited. Rather, U.S. persons are prohibited from engaging in certain types of transactions, principally in the financing and payment space, when prohibited by those sectoral sanctions. Finally, the last category of sanctions here is among the most vexing commercially and among the most aggressive. And that is the so-called secondary extraterritorial sanctions. And here what's really important is these sanctions don't rely upon an assertion of legal jurisdiction by the United States. Rather, these sanctions are designed not as an exercise of jurisdiction, but rather as an exercise simply of policy and penalty. And what I mean by that is that the secondary and extraterritorial sanctions are a set of conditions, a set of triggers, a set of behaviors that the U.S. says, if X, then Y. So if a person anywhere in the world, U.S. or non-U.S., is engaged in certain types of activity, so for example, if they are engaged in certain types of pipelaying activity involving Russian energy export pipelines, that activity, whether or not it touches the United States, whether or not the United States could assert jurisdiction for any other purpose, that activity alone may trigger the imposition of penalties on the people involved by the United States. Next slide, please. In administering these four types of programs, there are some key concepts, some key terms that, again, are common throughout the program of sanctions and that my colleagues will talk about throughout the course of our morning today. I want to focus on a couple of these in particular. The first is this concept of facilitation. And there are a number of U.S. sanctions programs that explicitly include an anti-facilitation provision. And the basic story here is that as a matter of U.S. sanctions, if you can't do it directly, you almost always can't do it indirectly. So you can't approve or finance or guarantee a transaction by somebody else if you can't do the transaction directly yourself. The second key term here is blocking or freezing. And this is how the United States controls property that's targeted, property that's within U.S. jurisdiction of people who've been designated. Now, here there's an important legal distinction. Title to this property doesn't change. Title to the property that's blocked stays with the target. What the blocking or freezing does is it prohibits the person who holds the title from exercising the powers and privileges that normally go with being the title holder, unless there's an authorization from OFAC. And blocking is automatic. It's freezing happens automatically as soon as sanctions are imposed, unless there's an exception. And the general rule is that once a U.S. person comes into possession or control of property in which a sanctioned person has an interest, that person's interest is blocked immediately, and the U.S. person has to file certain disclosures, certain reports to OFAC. The next key concept here is the 50% rule. This is something that OFAC only formalized within the last several years, and it's come to be incredibly significant commercially. So the 50% rule is relatively straightforward as written, but can be incredibly difficult to understand and apply in a commercial context. Under the 50% rule, any entity that's owned 50% or more, directly or indirectly, in the aggregate by a sanctioned person or group of sanctioned persons is automatically considered to be subject to the same sanctions as those 50% owners. So what this means is that if company X is designated for US sanctions, any entity that company X owns 50% or greater is itself automatically treated as if it were sanctioned, even though that entity, even though that subsidiary, even though its name very well may not appear on any US sanctions list. Now, the same holds true for the sectoral sanctions. If company X is subject to sectoral sanctions, company X passes along those sectoral sanctions, if you will, to any entity it owns 50% or greater. Again, those subsidiaries may not themselves be listed on any US sanctions list. And you can see how, as a matter of practice, this raises some really challenging compliance situations. I'll distinguish that 50% rule, which is focused on ownership, from the next concept, which is focused on control. And here, there's a really significant difference. The 50% rule is automatic. It happens by operation of law. Every night the sun sets, every morning the sun comes up. 50% rule ownership applies in just the same way. Control's a little bit different. So in order for a sanctioned entity to pass along that sanctioned status to entities it controls but does not own 50% or more, OFAC actually has to make an affirmative finding of control. So unlike the 50% rule, which is automatic, control is in a sense discretionary. Something else needs to happen first before an entity that is owned less than 50% can be considered to have passed along that sanctioned status to an entity that it controls. The last of the key terms here is licenses. And I mentioned a bit earlier that this idea of licensing goes back, as far as we can tell, at least to the American Civil War, when the Union set up a licensing regime for frozen Confederate assets. Licensing really means two different things. It means general licenses and specific licenses. A general license, often called a GL, authorizes a particular type of transaction for a class of persons without the need to apply for a license. So if there is a general license for X and what you're planning to do fits within the scope of X, you can go ahead and do it. You might have a reporting requirement to OFAC, but you don't need to request any additional authorization as long as you're within the scope of the license. A specific license is what needs to be used for any other circumstance. So unless there's a general license, if a license is required, you'll need a specific license. And specific licenses are written documents issued by OFAC in response to a request. And these are highly, highly discretionary. And we know from public reporting that OFAC receives tens of thousands of requests every year for specific licenses to authorize a particular transaction or class of transactions. Next slide, please. So here, I wanted to just provide a little bit more color on sort of how these different concepts intersect. So how do comprehensive sanctions and sectoral and list-based and secondary sanctions intersect with the types of foreign policy and national security concerns I mentioned earlier, and mindful of the operational concepts I just talked about. My colleagues later today and tomorrow we'll talk in a good bit more detail about a number of these different programs. But I wanted to just sort of lay these out here just to provide a little bit of structure, a little bit of color on, from a US perspective, how the rest of the world looks. Let me go to the next slide, please. I want to talk a little bit more about the specific application here when it comes to Cuba. So people know about the Cuba embargo, and in a sense, it's very straightforward. Sanctions are very straightforward in a sense. They prohibit things, they allow things, but applying these concepts, especially to a sophisticated business, can be really challenging. And the longstanding Cuba embargo, even though it is relatively black and white compared to many other sanctions programs, even though it's been around for decades upon decades, still highlights some of these challenges. We know Cuba is generally off limits, but the question is to whom and for what purpose? So when it comes to Cuba, just to walk it through for a minute, we do have a blanket embargo, to be sure, and it applies to persons subject to U.S. jurisdiction. And that means anybody who is a citizen or a permanent resident of the United States, means anybody who's in the United States physically, means any company that's organized under the laws of any U.S. jurisdiction, and it means any entity that's owned or controlled by any of these people. So a U.S. citizen owns, controls an entity outside the United States, that entity is still subject to comply with the embargo on Cuba. And the way the Cuba sanctions work is that essentially absent an authorization from OFAC or from its sister agency at the Commerce Department, which administers U.S. export controls, all of the people that are required to comply with the Cuba embargo, so in this sort of small bubble and the medium-sized bubble on this page, all of these people are required to comply with the Cuba embargo and generally prohibited from doing business with Cuba unless there's an exemption or an authorization. But that's really not the end of it, because what we've seen is that even people who are not themselves required to comply with the Cuba sanctions are still required to comply with U.S. export controls if there are U.S. origin goods or services involved, still required to comply with restrictions on transactions involving the U.S. financial system. And in recent years, the U.S. has even layered in some long dormant authorities that look like secondary sanctions, even though they don't use that terminology, which allow the U.S. to impose visa bans, for example, against the executives of companies who the U.S. says have trafficked and property confiscated by the Cuban government. So in short, even for a longstanding program that is widely known as being a blanket embargo on Cuba, there are nuances that can be significant from a compliance and enforcement perspective. Let me go to the next slide, please. Thank you. So let's take the Russia-related sanctions as another example. And I'm not going to dive too deep into this because my colleagues will talk about Russia very shortly in greater detail. The basic principle I want to illustrate here, though, is that even though there's no general embargo when it comes to U.S. persons and Russia, with the exception of transactions involving Crimea, there are nevertheless restrictions on the ability of U.S. persons to engage in transactions with specific Russian individuals and entities for specific purposes. Again, here, the scope of sanctions restrictions narrows when it comes to non-U.S. persons, non-U.S. entities. But again, we also have increasingly this sort of backstop, this overhang of secondary sanctions. And I'll highlight one in particular because it's essentially a catch-all. There is actually a provision of U.S. law, Section 228 of the Countering America's Adversaries Through Sanctions Act, or CAATSA, which allows the United States to impose sanctions on anyone, U.S. or non-U.S., who facilitates a significant transaction on behalf of a person subject to sanctions with respect to Russia. So in effect, that secondary sanction sort of collapses the distinction between U.S. persons and non-U.S. persons. Because if a transaction involves someone who is subject to sanctions under the US-Russia program authorities, certainly it's off limits for a US person, but now as a result of those secondary sanctions, it may be functionally off limits or at least subject to penalty by the United States, even if the transaction is only by a non-US person. Next slide, please. So to tie all of these things together here, there are a couple really significant compliance principles. The first, as I mentioned before, has to do with facilitation. If you can't engage in the transaction directly, or you can't engage in the transaction from the United States, you very likely can't engage in the transaction at all. What this means is if there is something that is sanctionable or prohibited for a US person, the US person can't help somebody else do it, even if the person they're helping is outside the United States and otherwise not subject to US jurisdiction. It's also important to recognize that there is no de minimis level. So there is no monetary threshold, no materiality qualifier at which sanctions start or stop applying. And what we've seen in recent years is several enforcement actions where the amount of sanctionable activity was really essentially a rounding error compared to the value of overall transactional activity. And from a US perspective, that does not make a whole lot of difference. Now, it certainly would go to the magnitude of any violation and the magnitude of any penalty. But as a basic principle, there is no de minimis amount. It's also important to note that when we talk about compliance, we're not talking about achieving the level of sort of omniscience and omnipotence. As high as the expectations are from the US authorities, as stiff as the penalties and costly as the penalties can be, what we hear from the US authorities consistently is that what they expect is for people to take a risk-based approach, where they are identifying the levels of risk and implementing policies and procedures and controls that are commensurate with addressing that risk. And what we saw in May of 2019 is, for the first time, OFAC published a cross-program framework for compliance commitments. So what OFAC expects across the board. And the 5 core components there are to demonstrate management's commitment, to perform risk assessments, to have internal controls and policies and procedures that are addressed to that risk assessment, to conduct testing and auditing, to validate the effectiveness of those controls, and to conduct training regularly. One of the common themes across all 5 of those verticals is documentation and record keeping. If it isn't documented in real time, it may not have happened, at least from the view of the US authorities. So with that, let me pause and turn it over to our next speaker.
Hi, everybody. Thanks, Peter, for that introduction. My name is Jason Silverman. I'm also a partner in the Washington, D.C. office. Today, I'm going to start off by talking to you about the Iran sanctions program. Next slide, please. So Peter sort of gave a preview of the numerous sources of sanctions that are out there. And the Iran program is one of the more mature sanctions programs that the US has. And sort of as a result of its evolution over time, it's really one of the more complicated sanctions programs in terms of the patchwork of statutes, regulations, and executive orders that make it up. These are just a list of the statutes that have been passed over the years, not even all of them, but some of the more recent ones that specifically address the situation in Iran and US foreign policy with respect to Iran. You know, as you can see, there's an immense amount of statutory authority for the regulatory agencies to draw on. a really diverse set of sanctions authorities that can be deployed against Iran and that have been deployed. Next slide, please. So when we talk about the Iran sanctions, we're actually talking about not just all those statutes, but where the rubber really meets the road is in the codified regulations. And in the case of Iran, there's actually 4 of them. The Iranian Assets Control Regulations, which are sort of the original blocking sanctions against the Iranian government, Iranian Transactions and Sanctions Regulations, the Iranian Financial Sanctions Regulations, and the Iranian Human Rights Abuses Sanctions Regulations. The 2 most commonly implicated sets of regulations and sort of day-to-day business are the ITSR, the Transactions and Sanctions Regulations, and the IFSR, Financial Sanctions Regulations. And today, just to kind of give you a flavor of what these restrictions are and how they work in practice, we're really going to focus on the ITSR. The IFSR pretty much deals exclusively with financial institutions, mostly foreign financial institutions, but we'll talk about that a little bit. So as of a couple of days ago, there were 26 executive orders relating to Iran, going all the way back to 1980. As far as I know, there haven't been any new ones issued today, but one of the hallmarks of sanctions programs in general, and the Iranian sanctions program in particular, is a rapid pace of change, and virtually every day there can be a new development, some of which we will talk about in connection with other programs that are seeing a little bit more action lately. There are also general licenses, which we'll talk about, and agency guidance, which can take the form of interpretive guidance, advisories to commercial actors, frequently asked questions, which are an excellent source of information. And in the case of the Iran program, at last count, there were well over 200 of them, and a list of medical devices requiring specific authorization is another part of key guidance. Next slide, please. So you've kind of seen a chart like this already. It's sort of a Venn diagram to highlight the layered application of sanctions, to whom they apply, and to what types of activities. This is really kind of a jurisdictional chart to explain the various categories of persons to whom the Iran sanctions apply. So the big red circle are U.S. persons. This is where the most stringent restrictions apply, where virtually all trade with or related to Iran is prohibited except for certain accepted transactions, medical supplies being one of them. That's why I highlighted the list of accepted medical devices, or medical devices requiring specific authorization, rather. Sort of the next set of somewhat less restrictive, but still quite restrictive, are non-U.S. entities owned or controlled by U.S. persons. Unlike some sanctions programs, the Iran program has a prohibition that applies to foreign entities that are owned or controlled by U.S. persons. The specific prohibition in the Iran program is that these entities are subject to the same prohibitions as U.S. persons as to any transaction with the government of Iran or any person subject to the jurisdiction of Iran. And then you finally get to non-U.S. persons, which is obviously the size. I think the size of these is meant to denote the extent of the restrictions rather than the number of people, because obviously there's more non-U.S. persons than U.S. persons. But as to non-U.S. persons, there's no general embargo, but there are secondary sanctions, which we will cover in some detail later in the presentation, that are a sort of a constantly vexing issue that non-U.S. persons have to deal with when dealing with Iran. The next slide, please. So the concepts that I'm going to cover in this segment are what do the Iran sanctions prohibit? Who must comply with them? This is sort of a jurisdictional question. In terms of what do sanctions prohibit, I'll get into those in a bit. In terms of who must comply, we've already talked a bit about U.S. persons. So there are a couple of terms that are frequently thrown around in discussing sanctions. One is primary sanctions, which is a term that typically refers to prohibitions that govern the conduct of U.S. persons, and in certain cases dealing in U.S. origin goods. And then there's this concept of secondary sanctions. And secondary sanctions are sanctions that can be imposed on non-U.S. persons for specified types of conduct. As Peter said, these aren't really prohibitions because they apply to people and entities who are not really subject to the jurisdiction of the United States. They're not really people that the United States can tell what to do or not to do and then punish them if they don't do it in like an administrative proceeding or criminal proceeding, but they're intended to impose restrictive measures on those people in an effort to influence their conduct. I have a definition of United States person here. This is a concept that runs through all sanctions programs with the sort of exception of Cuba. But just to reiterate, a United States person is defined as a United States citizen, United States permanent resident, entities organized under the laws of the United States and their foreign branches, and any person while in the United States. So, under that last one, even a foreign citizen who is, on business or leisure travel in the United States while in the United States is within the definition of a U.S. person. And again, the significance of this is that many of the prohibitions that apply under the Iran sanctions distinguish between U.S. persons and non-U.S. persons other than those owned or controlled by U.S. persons. Next slide, please. So I thought I would sort of give you an overview of some of the prohibitions under the ITSR, the Iranian Transactions and Sanctions Regulations. This isn't an exclusive list or an exhaustive list, but it covers the prohibitions that are most commonly encountered, again, in our practice certainly, and in the experience of many of our clients. So. One, importing goods and services into the United States from Iran. This is actually not limited to U.S. persons on its face, although by implication, if you're in the United States, you are a U.S. person, but there can certainly be instances where somebody is causing something to be imported into the United States. Two of really common ones that come up are exporting or re-exporting to Iran any goods or services from the U.S., or by a U.S. person, or exporting or re-exporting certain goods through Iran by non-U.S. persons. You'll remember that Peter in his scene setter talked about other regulatory agencies like the Department of Commerce and the ability of the United States to exercise controls over goods of U.S. origin. And these are the prohibitions under the Iran sanctions where that really comes into play. So there are significant restrictions on U.S. persons' ability to deal with any export of goods or services to Iran, or any person's ability to export or re-export certain goods to Iran. Another prohibition dealing in any goods of Iranian origin or providing goods to Iran or the Iranian government by U.S. persons. And finally, transactions in blocked property. This is property that is, either property that has, as Peter said, blocking occurs as a matter of law, whether a person actually has, frozen the assets or filed a blocking report with OFAC. This is a blanket prohibition on any transactions in blocked property. whether a blocking report has been filed with OFAC or otherwise. If the property is subject to being blocked under the regulations, there's a prohibition on dealing with it. Next slide, please. So there are several notable features of the ITSR, and these are not exclusive to the Iran sanctions, except for the first bullet point, or the first sub-bullet point. But there are ways in which the Iran sanctions prohibitions that may on their face apply to U.S. persons can actually be much broader than that in terms of the risks that they present to non-U.S. persons. So number one, I mentioned earlier, is this feature of the Iran sanctions that requires foreign companies, which are not U.S. persons, that are owned or controlled by a U.S. person, from engaging in transactions with the government of Iran or any person subject to the jurisdiction of Iran, if the transaction would be prohibited for a U.S. person to do. This obviously can create certain challenges with respect to multinational companies with foreign operations outside the U.S. As with other sanctions programs, there's a prohibition, an independent prohibition on causing violations, conspiring to commit violations, attempting to commit violations, or evading the prohibitions. And the Iran sanctions also have an express prohibition on facilitation. This is a concept that Peter also discussed, and it essentially refers to when a United States person helps a non-U.S. person to participate or pursue a transaction where a United States person could not perform that transaction themselves. So a couple of examples that are actually expressly in the regulations themselves that are clearly described as being facilitation are certain changes to policies to allow transactions that a U.S. person could not pursue, whether that change in policy occurs at the U.S. corporate level or the corporate level of an entity that it owns or controls, or referring a foreign person business that a U.S. person could not pursue, because in the sense that the foreign person is not on its face prohibited from pursuing it, but that act of referring it is considered facilitation. Next slide, please. Earlier, I mentioned general licenses. So, of course, there are always exceptions to rules. All of the prohibitions that I've been talking about and that we'll all be talking about today are prohibitions to the extent that the transaction is not otherwise authorized. There are ways of getting authorization. One is called a specific license, when a party to a transaction submits a written request to OFAC and asks OFAC to authorize that transaction. That's what I think most people kind of think of when they think of a license, is what is referred to in the OFAC space as a specific license. There are also general licenses, which are often in the regulations themselves. Sometimes they're standalone. Iran has a combination of both general license that are in the regulations and that are just sort of not codified in the regulations. A general license is an authorization of transactions that would otherwise be prohibited under the regulations and don't require a specific filing request to OFAC. They do all have specific terms and limitations, and many of them have reporting requirements, and all of them have record keeping requirements. And all of these requirements have to be complied with in order for the license to cover a transaction. Sort of a compliance point, it's very important to think in terms of, when facing a potential transaction that might have sanctions implications, to think through whether the prohibitions apply to it, and if they do, whether a general license authorizes it, and then to think of how to pursue that transaction consistent with that general license, it's very difficult to sort of luck into complying with the general license because of the complexity of the terms. And the reason that these are general licenses is that they all fall into certain fairly predictable categories. We'll probably see them repeated throughout several of these programs if we get into that level of detail. But they all are intended to authorize transactions that are consistent with or that advance U.S. foreign policy or national security interests. And I have some examples on the next slide. So there in the Iran program, there are several general licenses dealing with exporting food, medicine, and medical devices to Iran, both with the actual exportation of those items and also with respect to payments for those items. There are other general licenses that also deal with humanitarian activities. The reason for these is that obviously, a stated purpose of our sanctions program is not to punish the people in a certain country, but to influence the government to change. That's really not always how it works, but that's the stated intent. And in fact, most sanctions statutes, particularly the ones, well, including the ones involving Iran, expressly carve out humanitarian activities and food, medicine, and medical devices. So, but that's a very common general license. Exporting goods and services related to telecommunications and mail or personal communications. Again, the claimed intent of these is not to cut people off or make it difficult for them to keep in touch with the outside world, but it's to prevent the government from continuing to engage in its behavior. So there are general licenses in the Iran program for those types of activities, journalism and journalistic activities and publishing. And finally, since regulations are written by lawyers and we like to look after our own, there are numerous general licenses involving legal services and legal proceedings and other activities involving assertions of rights like intellectual property and pursuing litigation and that sort of thing. Next slide, please. So just talk briefly about secondary sanctions under the Iran programs, the Iran program. So again, what secondary sanctions means is these are restrictive measures imposed on non-US persons for certain conduct. So if a US person violates a sanctions prohibition and there's not an applicable general license, or if in the case of the Iran program, if a foreign subsidiary that's owned or controlled by a US person engages in conduct with the government of Iran or a person subject to the jurisdiction of Iran, that a US person couldn't pursue, they could face financial penalties. OFAC can issue them a penalty notice. In willful cases, there's obviously exposure to criminal prosecution, but for non-US persons who are not subsidiaries and who otherwise don't have any activity in interstate commerce in the United States, for instance, there really isn't a legal mechanism for OFAC or the Justice Department to pursue those people. So that's the reason why there are secondary sanctions, which allows OFAC to impose restrictive measures, which I'll talk about exactly what those are in a bit, on non-US persons. These are the types of sanctions that were the subject of the sanctions relief under the Iran nuclear deal or the JCPOA, and which were subsequently rescinded or scaled back. Well, they were really completely rescinded by the Trump administration. Those almost entirely involve secondary sanctions. There are in the case of secondary sanctions involving Iran, there are certain authorities that apply specifically to foreign financial institutions, but then there are other authorities that apply to any person. A key concept in secondary sanctions, and one of the greater challenges of assessing secondary sanctions risk is the concept of a significant transaction. A hallmark of many secondary sanctions authorities, although not all of them, is that they make sanctionable if a person knowingly participates or conducts a significant transaction. So again, it's not a strict liability offense, like Peter was saying. Some sanctions requirements are strict liability. They don't have a mens rea requirement. Secondary sanctions do. They require the person to act knowingly, and they many of them require the transaction to be significant. Well, what does that mean? I'm not going to read the definition of significant transaction for you, but it's printed there in small print, and it has multiple elements of things that OFAC can consider when determining whether a transaction is significant, and the real kicker is that the last one is, it's kind of difficult to read it as anything other than a blank check. It's other relevant factors that the Secretary of the Treasury deems relevant. So in addition to all these, 7 or 8 other factors, the Secretary of the Treasury can just sort of take other things into account. It makes it difficult to predict what that might be. With respect to secondary sanctions, though, OFAC has said that it will seek to engage with persons that it thinks may be engaging in conduct that is sanctionable, to try to persuade them to stop. Now, that is not a regulatory requirement. It's not in any regulations. It's just something that OFAC has said that they will do. But it is an aspect of how secondary sanctions work that it's important to keep in mind. Another thing to note about secondary sanctions is that there are likewise exceptions relating to humanitarian trade, and for transactions for which a U.S. person would not require a specific license. In other words, if many general licenses are written specifically to relieve a person of an obligation, so since those obligations are largely aimed at U.S. persons, a lot of the general licenses only really speak in terms of U.S. persons. But if a non-U.S. person is going to engage in a transaction that, if they were a U.S. person, it would be covered by a general license, that conduct is not considered a significant transaction under existing OFAC guidance. Next slide, please. So some of the secondary sanctions that can be imposed, these are the restrictive measures. These are often called, sometimes they're referred to as menu-based sanctions, depending on the type of secondary sanctions that are being imposed. But the idea is that there is a range of sanctions that can be imposed on a person where the Secretary of Treasury, often in consultation with the Secretary of State, deems to be engaged in sanctionable activity. The most sort of severe of these is blocking sanctions, where the person is actually added to the list of specially designated nationals and their property subject to U.S. jurisdiction becomes blocked. People can be banned from the United States. There can be a denial of Ex-Im bank financing, government contracting debarment, licensing debarment, which, meaning licensing in the sense of export licensing, where the relevant export licensing authorities will not issue export licenses to a person who has been subject to this restrictive measure. Restrictions on loans from or equity investment by U.S. persons, and for financial institutions, restrictions on foreign exchange, correspondent and payable through accounts and transactions. And some of these sanctions were actually just imposed yesterday, not in connection with the Iran program, but we will talk about those in a bit. Next slide, please. Then to give you an idea of some of the conduct for which the U.S. will impose secondary sanctions on non-US persons. These are just a few examples. Now, this is not an exhaustive list. This is, I think it would be fair to describe the secondary sanctions authority under the Iran program as sort of a web of authorities that includes executive order. They all stem from statutory authority, obviously, but there's it can be found in executive orders and also the regulations that we've talked about. Both the ITSR and the IFSR contain secondary sanctions provisions, but a couple of recent executive orders target certain sectors of the Iranian economy. So these both authorize the designation or the blocking of entities in Iran that are deemed to operate in the various listed sectors. So in the case of the more recent one, 13902, these are construction, mining, manufacturing, and textiles, or other sectors specified by the Secretary of the Treasury, one of which was recently the financial sector, which was added to that list. And then 13871 is iron, steel, aluminum, or copper sectors. And so the way these work is that the Secretary of the Treasury can designate these sectors as being sanctionable and can add entities deemed to operate in those sections to the SDN list, and then can add entities that are not part of those sectors, but that engage in certain sanctionable activity with those sectors to the SDN list or subject them to the other restrictive measures we discussed on the last slide. So, for instance, significant transactions for the sale, supply, or transfer to or from Iran of significant goods or services used in connection with these sectors, or significant transactions for the purchase, et cetera, of iron, aluminum, steel, copper, et cetera, products from Iran are sanctionable activities under these executive orders. Next slide, please. Sort of the big executive order, I won't go through all of these, but and it's also a couple of years old, but this is the executive order that reimposed secondary sanctions that have been suspended under the JCPOA. So like I said earlier, this is not the only source of these sanctions. They stem from statutory authority, and a number of them are also covered in the IFSR or ITSR. But this gives you an idea of the type of conduct that can be targeted. And one that comes up with a pretty good degree of regularity is a significant transaction or significant financial material or other support to certain people on the SDN list. So that, again, these can both target the activity itself. So activity involving the automotive sector or activity involving petroleum or petroleum products, but they can also target activities with specific entities, either NICO or NIOC, the state-owned oil company, or SDNs, people on the SDN list. So I thought I'd give a sort of a little bit of couple of minutes in the short amount of time that I have left to talk about sort of where things might go from here, since we're at a bit of an inflection point in U.S. Politics and foreign policy. For those of you who have followed the Iran sanctions closely over the past few years, none of this will be news, but just as a quick scene setter, you've probably heard about the Iran nuclear deal. It was an accord involving us and many of our allies and Iran, aimed at encouraging Iran to reduce its nuclear activities. This was entered by the Obama administration. It was subject to review by Congress at that time, but it became sort of a political football, or was made a somewhat political football, and encouraged by the Trump administration, which made it sort of like a mission to undo that, along with several other things that the Obama administration accomplished. So in 2017, I might be getting the dates wrong, but it's been a number of years since we unilaterally withdrew from the JCPOA, and this executive order was issued sort of unwinding the sanctions relief that came along with the JCPOA. The incoming Biden administration has clearly signaled an intent to return to the JCPOA. There's a significant open question about what form that would take, whether it would be a return to the current deal or involve an effort to renegotiate certain aspects of it prior to returning. There is bipartisan support in Congress for putting stricter provisions on some activity that wasn't covered by the JCPOA because it wasn't strictly nuclear, but ballistic missile program, Iran's ballistic missile program, independent of its nuclear program. Renegotiating a multilateral agreement bilaterally when we withdrew from it unilaterally is not the best negotiating position. But at the same time, Congress can be expected to act as a check on future sanctions relief that the Biden administration may seek to offer. And I think it can be expected that the Biden administration will seek to at least curb some of the secondary sanctions authorities reimposed by Trump or imposed anew. But I think that that will take some time. I don't think anyone expects to see sort of a rapid return to Obama era sanctions sort of in the 2016 timeframe, immediately after January 20th. So with that, let's see, I don't know if there are any questions in the chat. Nope. With that, I will turn it over to my colleague Sharzad, who is going to talk about Russia sanctions.
Thanks, Jason. Hi, everyone, and thank you so much for joining us today. My name is Shahzad Norbaluchi, and I am in Dentons' Federal Regulatory and Compliance Practice, where I focus on economic sanctions and other trade sanctions-related matters. So I will be outlining the current status of U.S. sanctions against Russia, and we can go to the next slide, please. U.S.-Russia sanctions are largely aimed at changing Russia's behavior to align with U.S. policy in several key respects. These include with respect to Russia's invasion of Ukraine, interference in U.S. elections, other malicious cyber activities, human rights abuses, use of a chemical weapon, weapons proliferation, illicit trade with North Korea, and support to Syria and Venezuela. In addition, recent U.S. policy has, with increasing emphasis, focused on curbing Russia's expansion of influence via the building of energy export pipelines in the Nord Stream 2 and Turk Stream projects. To achieve these policy goals, the U.S. maintains a variety of primary and secondary sanctions related to Russia. As Peter mentioned, while the majority of these restrictions apply to U.S. persons, in that they are primary in nature, certain U.S. sanctions are also applicable to non-U.S. persons. So I'll outline those shortly. Next slide, please. Current primary sanctions fit into three general categories: blocking sanctions, the embargo on Crimea, and sectoral sanctions. As to blocking sanctions, the U.S. has imposed such sanctions on a wide range of Russian and Russia-related individuals and entities through several executive orders, including Executive Order 13660, 13661, 13662, and 13685. These executive orders allow the Secretary of the Treasury to block or freeze the property and interest in property within U.S. jurisdiction of any person that has been found to operate in Crimea, be a leader of an entity in Crimea, be owned or controlled by, or have acted or purported to act on behalf of persons whose properties are blocked, or to have materially assisted such persons. In addition to blocking sanctions, the US also maintains an embargo on Crimea, as was mentioned previously. The embargo on Crimea prohibits US persons from engaging in most transactions with that region unless they get a license from OFAC. Specifically, EO 13685 prohibits US persons from both importing and exporting goods, services, and technology from or to Crimea. In addition, the EO also prohibits US persons from facilitating non-US persons to engage in the above transactions. Jason alluded to these anti-facilitation provisions previously. Finally, the US also has in place what we call sectoral sanctions. And if we can move to the next slide. There are two important things to remember about sectoral sanctions from the outset. First, they don't prohibit US persons from engaging in all transactions with a sectorally sanctioned person, or what we call an SSI. Rather, they only place certain limits on certain types of transactions that US persons can engage in on certain dates. So they're limited in several respects. Second, sectoral sanctions don't require US persons to block or freeze the property of the SSI. Instead, they restrict the types and duration of financing that US persons can provide to entities in the sectorally sanctioned sectors. These persons are named to the SSI list. OFAC has implemented these sanctions through 4 directives, directives 1 through 4, which I'm just going to briefly overview. Directive 1 applies to Russia's financial sector and prohibits US persons from dealing in the new debt of specified tenors or new equity of persons operating in that sector as named in Directive 1. And the tenor of prohibited debt depends on the period when that debt was issued. Directive 2 applies to Russia's energy sector and prohibits US persons from dealing in the new debt of specified tenors or new equity of persons operating in Russia's energy sector as named in Directive 2. Directive 3 targets the defense and related materials sector and prohibits US persons from engaging in all transactions in provision of financing for and or dealings in new debt of longer than 30 days maturity of persons determined to be subject to the directive. For purposes of all of these directives, OFAC has defined the terms debt and equity broadly. So the term debt includes bonds, loans, extensions of credit, loan guarantees, among other things. And the term equity includes stocks, share issuances, and other evidence of title or ownership. Finally, Directive 4 also applies to Russia's energy sector and imposes 2 prohibitions on the provision, exportation, or re-exportation of goods, services, or technology in support of the exploration or production of certain deep water, Arctic offshore, or shale projects in or related to Russia. First, Directive 4 prohibits providing goods, services, or technology in support of exploration or production of deep water, Arctic offshore, or shale projects that have the potential to produce oil in Russia and that involve any person determined to be subject to Directive 4. And second, Directive 4 prohibits providing goods, services, or technology in support of exploration or production for deep water, Arctic offshore, or shale projects that meet several criteria. First, the project has to have been initiated after January 29th, 2018. The project must have the potential to produce oil in any location, and persons subject to Directive 4 have to have a 33% or greater ownership interest in the project or own a majority of the voting interests therein. And notably, none of the directives reach financial services, so the provision of this type of service is not subject to the prohibitions in any of the 4 directives. Next slide, please. In addition, the US also maintains a growing range of secondary sanctions. These include sanctions under CATSA, the Ukraine Freedom Support Act of 2014, support for the Sovereignty, Integrity, Democracy, and Economic Stability of Ukraine Act of 2014, and the Protecting Europe's Energy Security Act of 2019, or PISA. As Peter alluded to, sanctions Sections 226 and 228 of CATSA are the only two provisions in the Ukraine-Russia related sanctions that apply to all transactions involving Ukraine, Russia-related SDNs. All of the other U.S. secondary sanctions provisions are more limited. So I will outline some of the most relevant secondary sanctions in a bit more depth. First are those under CATSA. Pursuant to CATSA, the U.S. Can or must impose certain penalties on any person that engages in certain types of transaction with Russian persons, regardless of whether those transactions are lawful under the laws of the applicable non-U.S. jurisdiction. Secondary measures available under CATSA include those aimed at corruption within the Russian government, in Section 227, human rights abuses in territories controlled or occupied by the Russian government, transactions with the Russian defense and intelligence sectors in Section 231, which were just used yesterday to target Turkey's presidency of defense industries. And I understand that we have a question specifically with respect to that action. So I'm going to pause here and let Mike take it away for that question.
Sure. So, as Peter and Jason both mentioned, sanctions can change pretty rapidly, and this is a really good example of it. So the 231 provisions of CATSA were specifically designed to target entities or individuals that engage in transactions with the Russian defense and intelligence sector. And so yesterday, this authority, just by way of background, and as Peter had also mentioned, sometimes you have multiple agencies acting at the same time. And so this is one of those examples because the 231 authority under CATSA was actually given to the State Department to execute as opposed to Treasury. So yesterday, the State Department announced additional CATSA sanctions under 231, specifically targeting the Turkish Ministry of Defense. This decision was related to the 2017 acquisition by the Turkish Defense Ministry, or the Presidency of Defense Industries, the SSB, of a set of military-grade S-400 missile systems that essentially were manufactured by the Russian government. This surface-to-air missile system has been an issue of some contention between the U.S. and Turkey for some time. And there have been a number of instances in which the State Department and the U.S. government have highlighted this purchase as being potentially sanctionable. And so when, in sort of the final analysis, when the Turkish government elected to proceed, after some consideration, that the U.S. decided to designate the Turkish Defense Ministry, the SSB, and several senior Turkish government officials as being subject to 231. So as Shahrzad will talk about, and as others have mentioned, sometimes when you're dealing with secondary sanctions, there's a number of menu-based sanctions that can be deployed. So not all of the sanctions are always used. Under 235 of CATSA, in the event that there's a 231 designation, you have to choose up to 5 or 5 from a list of 12 available sanctions. And so in this case, the 5 menu-based sanctions that were imposed on the SSB were export license and related export restrictions from the US to the SSB. That's probably the most significant here because that one, although will ultimately be enforced by the Commerce Department, prohibits essentially any licensing of technology or U.S. origin goods to the SSB for the period of time in which these sanctions are in place. The other options off the menu included a bar on loans or credits from U.S. financial institutions that exceed 10 million in any 12-month period, a ban on assistance from the U.S. Exim Bank, requirements for the U.S. to oppose any loans to the SSB by international financial institutions, and then a set of specific individual blocking sanctions, which will be imposed by Treasury, so designation as an SDN, for several Turkish government officials who are involved with the SSB. So what does that mean in the short term? Well, the most significant ones in terms of their impact are likely to be the export restrictions. Those are usually pretty meaningful. We've seen that deployed. We'll talk about that a little bit in the China section as well. You know, export control restrictions can be a pretty substantial and impactful way of targeting foreign entities, because it prohibits the licensing of U.S. origin technology for again, it remains to be seen how the Turkish government responds to this, since it just happened yesterday. But the export issue may be quite significant. The other piece that is also notable, given OFAC's 50% rule, is that the individual Turkish government officials who were sanctioned will be blocked from transactions involving U.S. persons, but so will any entities that they own or control greater than 50%. So as a practical matter, overnight, virtually every financial institution is going through and looking at their commercial partnerships and looking at their customer lists, and as are any other U.S. persons, to assess and evaluate whether the individuals or the SSB itself has subsidiaries that may be subject now to blocking sanctions or other restrictions. So in the near term, those are likely to be the most substantial impacts. It's not the first time that the U.S. has quickly layered on sanctions against Turkey only to rescind them later. So there may very well be a pivot off this position, although this one has been some time in formation and is likely to persist, especially on the export side for a little bit of time. But we'll have to see how that evolves. But it is a great example of how these catch-up provisions sort of can jump up out of nowhere and be deployed in seemingly unrelated contexts, simply because of the broad sweep of these various prohibitions. So virtually any touch to a Russian government enterprise, as we're seeing here, even at the nation state level with Turkey, can expose not just state actors, but also commercial actors to secondary sanctions.
Thank you, Mike. So yeah, I have a few more of these secondary sanctions provisions there, and I'm not going to read the rest of them, but you can see there that there are others. I'm going to now turn my focus to sections 228 and 226, which, as Peter mentioned, are the most broad provisions under CATSA. If we can go to the next slide, please. So CATSA section 228 specifically requires the president to impose blocking sanctions on any person that OFAC determines has knowingly facilitated significant transactions for or on behalf of any person subject to U.S. sanctions with respect to the Russian Federation. This is very broad, obviously, and includes specially designated nationals as well as SSIs. Persons found to have knowingly facilitated significant transactions with a blocked person can themselves be added to the SDN list. OFAC determines whether any particular transaction is significant on a case-by-case basis based on the totality of the facts and circumstances, which Jason already mentioned, and these factors include things like the size, number, and frequency of the transactions, the nature of the transactions, and several other factors. And of course, as he mentioned, OFAC is authorized to consider any factor that it deems relevant. So the authority there is very broad as well. Unlike transactions involving an SDN, where Section 228 is concerned, a transaction involving only an SSI must involve deceptive practices, such as obstruction or evasion, to be considered significant. And that's based off of guidance that OFAC has provided in its FAQs. It's not written in the text of the regulation or the statute. Next slide, please. In In addition, CATSA Section 226 also applies pretty broadly, but to financial institutions. Section 226 requires the president to prohibit the opening of a U.S. correspondent or payable through account, or prohibit or impose strict conditions on the maintenance of a U.S. correspondent or payable through account for a foreign financial institution that knowingly facilitates a significant financial transaction on behalf of any Russian person on the SDN list after September 1, 2017. Next slide, please. Another commonly encountered secondary sanctions prohibition under CATSA is Section 232. Under Section 232, the president may impose a range of sanctions against any person, U.S. or non-U.S., who knowingly makes investments that directly and significantly contribute to the enhancement of Russia's ability to construct energy export pipelines, or provides to Russia for the construction of Russian energy export pipelines, goods, services, technology, information, or support. To be covered, the investment or support must have a fair market value of more than $1 million for single items, or an aggregate fair market value of $5 million or more during a 12-month period for multiple items. Goods, services, technology, information, or support for purposes of this sanctions authority are defined as goods, services, technology, information, or support that could directly and significantly facilitate the maintenance or expansion of the construction, modernization, or repair of energy export pipelines by the Russian Federation. Based on updated guidance from the U.S. Department of State, the focus of Section 232 is now going to be Nord Stream 2 and the second line of Turk Stream. And the State Department has also stated that it intends to interpret the term investment broadly to include any commitment or contribution of funds or other assets, or a loan or other extension of credit to an enterprise. And we're seeing actually around this a lot of enforcement activity currently, with the State Department reaching out to parties that it has deemed involved in potentially sanctionable conduct. Next slide, please. Also related to these energy export pipelines is PISA, which was enacted in 2019. PISA requires the president to impose blocking sanctions on foreign persons determined by the Secretary of State in consultation with the Secretary of Treasury to have knowingly sold, leased, or provided vessels for the construction of the Nord Stream 2 pipeline, the Turk Stream pipeline, or any successor project, or facilitated deceptive or structured transaction to provide those vessels for such a project. The corporate officers and principal shareholders of any company owning vessels that are engaged in pipelaying at depths of 100 feet or more below sea level for the construction of these projects can also face visa denials and be prohibited from entering the United States. In addition, Congress just Friday adopted PISA, the latest National Defense Authorization Act, which expands upon PISA. PISA is the Protecting Europe's Energy Security Clarification Act, and it expands on PISA by sanctioning pipe laying activities in addition to mere pipe laying, which was targeted under PISA. Pipe laying activities are defined to include activities that facilitate pipe laying, including site preparation, trenching, and surveying, among other types of activities. PISA also authorizes sanctions against foreign persons determined to have knowingly provided underwriting, insurance, reinsurance, and other types of services that facilitate technology updates or installation of welding equipment for the vessels identified by the Secretary of State pursuant to PISA. So as you can tell, PISA allows for a broader reach by the United States over non-US persons for engaging in a larger scope of activities than was the case under PISA. Next slide, please. Quickly, I just wanted to touch upon certain other actions that are administered not by OFAC, but by other agencies, but that are very closely related and impact people operating in this space. So these are actions administered by the Department of Commerce's Bureau of Industry and Security, also known as BIS, and they include largely, there are others, but the two main that I'll cover now are the Russia industry sector sanctions and military end use and end user restrictions. Next slide, please. Under the Russia industry sector sanctions, specific licensing requirements apply to exports of certain U.S. origin goods to Russia, where the person conducting the export knows that the U.S. origin items, software and or technology will be used directly or indirectly in exploration for or production of oil or gas in Russian deep water or Arctic offshore locations or shale formations, or where the person conducting the export is unable to determine whether the item will be used in these projects. These Russian industry sector sanctions administered by BIS apply to items that fall under either specified ECCNs or export control classification numbers or certain enumerated HTS codes. These include certain types of line pipe used for oil or gas pipelines, certain oil well drill pipes, certain oil well tubing and casings, among various other items. There's a presumption of denial for any license requests for exports falling within these sorts of sanctions, so-called. These restrictions have a broader impact than the sectoral sanctions maintained by OFAC, which are focused on debt and limited to certain designated entities. Next slide, please. BIS also recently imposed significant new restrictions with respect to exports and re-exports to military end users and towards military end uses in Russia. These new restrictions now require a license for certain exports where the exporter has knowledge or a reason to know that the item is intended for a military end use in Russia. The new restrictions expand the definition of military end use to cover items exported that support or contribute to the operation, installation, maintenance, repair, overhaul, refurbishing, development, or production of military items. They also expand the list of products subject to these restrictions to cover items related to materials, processing, electronics, telecommunications, information security, sensors and lasers, and propulsion types as identified by their export control classifications numbers. And I think with that, I will hand it back over to Mike to discuss China and Hong Kong related authorities.
Great. So nice to be back with all of you again. This is really an interesting program, the China and Hong Kong sanctions. It's interesting for two main reasons. One is sort of the scope of federal agencies in the US that are involved in implementing various parts of the sanctions program. And second, for the breadth of and scope of sanctions programs and authorities that are being used and deployed here in a broader foreign policy objective. Next slide. As Peter talked about when we sort of began this journey about an hour and a half ago, one of the things about US sanctions programs is that they are a tool of foreign policy and they are designed to change behavior. So when you look at the ongoing sort of geopolitical climate between the US and China, it should come as no surprise that the sanctions components and the involvement of multiple agencies as part of the US foreign policy strategy towards China are implicated here. There's multiple areas of focus for the US foreign policy and sanctions tools being deployed in the realm of US-China relations. A wide variety of US agencies involved. And as a consequence, the impacts to business from the China sort of foreign policy strategy and sanctions authorities tend to be pretty significant. Next slide. So there are a number of different focus areas from a US foreign policy perspective that are involved in the US-China relationship and hence in the US sanctions programs. The first is related to cybersecurity. So concern, sort of broad spectrum concern about the involvement of the Chinese government in gaining access to US technological systems, US telecommunication systems, and the use of technology to gain that access. So we'll talk a little bit about the procurement related restrictions that are involved here, as well as the designation under both sanctions authorities, but also the Commerce Department about specific technology providers in China and the issues related to granting them access to US systems. This also shows up from a cybersecurity perspective in a topic that is not sanctions related, but definitely national security related, which is inbound foreign investment into the US. Certainly a topic for another day, but as a practical matter, understand that when the US looks to cybersecurity, they're also focused on the acquisition of US companies and whether the technology backbone provided by those companies could be hacked or used to gain access to other US systems. Human rights is another big area, targeting specific instances of forced labor in the Xinjiang province, but more broadly, looking at China as a frequent purchaser of and supplier to North Korea. And then the involvement in other sanctions programs. So the looking at Chinese entities, Chinese companies that are involved in sales to or support for the Iranian regime and the Maduro government in Venezuela. Next slide. So what does this look like across sort of the US government architecture? Well, under OFAC, there's the Hong Kong Autonomy Act and its implementation. That's the most recent development, which is the concerns over crackdowns on Hong Kong's autonomy and relative independence from the rest of mainland China. Executive Order 13936, which also sort of follows the HKAA, but relates more broadly to, again, using a phrase borrowed from other programs, malign conduct. And then the global Magnitsky sanctions, which are human rights and anti-corruption focused. Peter will talk about the application of GLOMAG later on in this program, but I think it's important to highlight here that it is being used specifically with respect to China in a way that is slightly different from its other applications. The Commerce Department also getting in on the action, designation of a number of Chinese firms to the entity list, therefore and thereby prohibiting exports of US origin goods to those entities and creating a presumption of denial for licenses where they are required. And also the designation of specific Chinese firms that are tied to Chinese government authorities or Chinese military infrastructure. This caused quite a stir about a month ago when a allegedly leaked list of potential targets for those sanctions made their way into the press and into the public domain, only to be sort of squashed by the Commerce Department and saying that it was not complete and that there's still more work to be done there. But these designations come under similar authorities, but are also equally relevant from a not purely sanctions, but certainly a restriction perspective when talking about trade. Also, the Department of Homeland Security, Customs and Border Protection, they're focused on seizure of goods that are produced with forced labor. So again, not exactly the same sanctions authority that we're talking about under the Hong Kong Autonomy Act or Global Magnitsky, but nevertheless, CBP and Homeland taking a hard look at inbound goods that may have been produced in the Xinjiang province or with forced labor more broadly. And then the Department of Defense also has a role to play here in the 2019 National Defense Authorization Act. Provisions of that piece of legislation that became law last year placed limits on the ability of the US government to sign contracts with companies that have a technology that is of certain Chinese origin. And then in addition, the Department of Defense itself went through a process of designating specific entities that they view as connected to the Chinese military or the People's Liberation Army. So you can see here that that China arena is becoming increasingly crowded and has been under this administration. Unclear how much of this will be retained in 2021 when we see a new presidential administration. But it's important to recognize that this is one of those areas where the sort of comprehensive nature of sanctions cutting across government agencies, cutting across different types of authorities is really quite pronounced. Next slide. So the basis for the sanctions, what is the underlying sort of rationale and legal authority to impose these sanctions are one, Chinese officials that are involved in undermining Hong Kong's autonomy. That includes those who were directly involved in government in Hong Kong, but also mainland China. As a follow-on from that, foreign financial institutions that provide material support to designated individuals or entities can also be targeted for sanctions. We've talked about secondary sanctions and sort of follow-on sanctions. This is another area where the material support provision makes an appearance. Government officials or Chinese firms that are responsible for or complicit in human rights abuses in Xinjiang. That is the more recent use of global Magnitsky, but it has been used to specifically target the activities of the Chinese government in the Xinjiang province, and potentially can be expanded to include firms and companies that operate in that same province. And then prohibitions on contracts to any entity that utilizes systems that are made by or significantly incorporate technology from specified Chinese technology companies. This is also, from a commercial perspective, something that creates challenge because, again, the lack of precise definitions around how extensive the significant incorporation needs to be before you are at risk is not precisely clear. But these are a wide-ranging set of tools aimed at kind of a increasing list and roster of Chinese firms, including several large ones that are largely integrated in terms of their systems, but also involved in sales and activities globally, and so therefore are widely deployed. So this is the U.S. sort of reaching out into a significant commercial arena to try to change, again, behavior of the Chinese government, either with respect to their human rights practices, specifically in mainland China, or more broadly trying to change their behavior in terms of various allegations of cyber hacking or accessing US systems in an unauthorized fashion. Next slide. So in terms of recent developments, you can see again sort of how it's not precisely a Hong Kong related sanction, but the US government is designating Chinese firms for their actions elsewhere in the world. So CEIC is designated under the Venezuela program. That occurred quite recently. They were targeted both under the Venezuela sanctions, which we'll talk about later, but also because of their ties to the Chinese military. And therefore you see sort of a double whammy of targeting Chinese entities that are involved both globally in terms of providing technology, but also specifically with respect to other foreign policy objectives such as those in Venezuela. The first report under the Hong Kong Autonomy Act, which was required, was issued in mid-October, so just about 2 months ago. That identified 10 individuals, and as a consequence of that, those same individuals who were earlier designated by OFAC in August, this report being issued in October now moves to a point where financial institutions may face sanctions for providing accounting services, banking services, or other material support to those same 10 individuals. So this is essentially the same people designated earlier in the year in August, but the follow-on impacts by being listed in this report under the HKAA means that banking institutions in Hong Kong or elsewhere can now be targeted for their own conduct that itself is a trigger for sanctions going forward. Also, the global Magnitsky designations related to Xinjiang, that occurred in July of this year, and a joint issuance of supply chain advisory related to the same types of conduct in terms of human rights abuses being issued by the Commerce Department in the form of BIS and by Treasury with OFAC being issued in early July. So taking these sort of in reverse order, what you see is that these programs are being deployed across multiple agencies, very frequently connected to one another. So you see the early July issuance followed by GLOMAG designations in relation to the advisory. And then sort of further actions that are occurring under the HKAA, but practically speaking, they're all integrated. So one thing to keep in mind here, and I know it's something that was mentioned in other programs, is that OFAC issues these advisories, and they are not carrying the force of law. They do not carry with them designations. But quite commonly, when OFAC issues an advisory, particularly one in coordination with other agencies, you very shortly thereafter see specific designations or targeting of entities or individuals or enforcement cases that follow the advisory. So, one thing that we often talk about is, why do you pay attention to these OFAC advisories? And the reason is because they really are an excellent roadmap to where the agency is headed in terms of its enforcement and designation authority. Next slide. So what does all of this mean in the commercial context? Well, supply chain disruption is a major one. We're seeing a lot of interest from companies who operate globally or source product in China about how they can ensure themselves that they are operating consistent with these new sanctions designations, and that they're not complicit in human rights abuses by virtue of having suppliers who are in mainland China. So that's an area right now of sort of increased focus, especially with the Customs and Border Protection seizures that are occurring sort of simultaneous with all of these sanctions authorities and sanctions designations. In addition, China has responded, and one of the ways in which they've responded is to really crack down to the extent they had not already on access to VPNs and other types of internet restrictions, both in mainland China and in Hong Kong. We're seeing that in a number of instances, firms that traditionally had supplied VPN services or companies that required VPN services to operate in Hong Kong are now receiving sort of extra notifications from their service providers that they may no longer be able to successfully provide those services, or requesting far more information and far greater detail about the specific individuals and entities in mainland China that need to access those systems. So again, China responding to US sanctions by trying to get their arms around the limitations and swiftly respond to gain better understanding about what's precisely happening. We're also seeing that folks are using enhanced due diligence or demanding enhanced due diligence from suppliers with respect to their operations in China, with respect to the source of product being shipped, and with respect to the partners that they have either in mainland China or in Hong Kong. Increased certifications related to the use of Chinese technology in business operations as a result of the procurement restrictions that were included in the federal acquisition regulations and in last year's NDAA. US companies in some instances are requesting that their foreign partners, that their foreign suppliers certify that they're not operating systems that significantly rely on the support of Chinese technology providers. Again, there's a specified list of those entities that were subject to this increased sort of set restrictions, but practically speaking, it means that there's certifications now being required of those who are sort of partnering with U.S. government contractors to make sure that they're operating consistent with this requirement. This has sort of taken on a bit of a life of its own in some respects, as we get and see questions that are far in excess of what one might ordinarily think. I mean, we've had at least a couple of clients who've reached out to us asking whether the fact that they have closed circuit TV cameras at one of their facilities that was supplied by a Chinese manufacturer means that they are using a system that is significantly reliant on Chinese technology. So obviously, these sanctions programs, when they have a lack of clarity, really do create challenges for business as they try to navigate a sort of undefined landscape. And then the last point here is sort of increased licensing requirements on sales of U.S. components or technology incorporating U.S. origin items. Far more due diligence about where the end users and end uses are, far more concern about inadvertently or via diversion supplying to Chinese companies that are on the restricted list, either from an SDN perspective or from a DoD or BIS perspective. So quite a lot happening here in this space that really does make it a new environment for business as they try to navigate it. So with that, we'll move sort of closely next door to North Korea. We'll go from China over to North Korea.
All right, thank you. I will now turn to providing an overview of the current landscape of North Korea sanctions and outline some of the latest developments and trends that we're seeing with respect to these sanctions. The U.S. has maintained a comprehensive trade embargo with respect to North Korea for more than a decade. This U.S. sanctions regime complements and expands on existing international sanctions that are maintained by the United Nations and other nations globally. U.S. sanctions targeting North Korea are largely designed to impede Pyongyang's development of missile and nuclear technology, but have also expanded to respond to certain other behavior perceived as malign by the United States, such as cyber attacks, human rights violations, censorship, and money laundering. Pursuant to the embargo, imports, exports, and facilitation of transactions involving North Korea are prohibited. More specifically, pursuant to Executive Order 13570, goods, services, and technology from North Korea may not be imported into the United States directly or indirectly without a license from OFAC or an applicable exemption. This includes goods, services, and technology from North Korea that are used as components of finished products or substantially transformed in a third country. Similarly, pursuant to Executive Order 13722, goods, services, and technology may not be exported or re-exported directly or indirectly to North Korea from the U.S. or by a U.S. person wherever they may be located, except where authorized. Exports to North Korea can be subject to both U.S. sanctions and export controls. In addition, the EO also prohibits new investments in North Korea by U.S. persons. Next slide. In the last year, the United States has continued to increase pressure on the North Korean government via the issuance of 3 separate sanctions advisories targeting the country's illicit activities in the cyber and maritime sectors, and amending and expanding the scope of the North Korea sanctions regulations. The U.S. has also pursued criminal indictments of U.S. sanctions evaders that supported the country's nuclear program. Next slide. In addressing increasing cyber threats from North Korea, on April 15th, the Department of Treasury, together with the Departments of State and Homeland Security and the FBI, issued an advisory highlighting the cyber threat posed by North Korea and outlining recommended measures for mitigating threats identified. The advisory noted that malicious cyber activity by North Korea poses a significant threat to the integrity and stability of the international financial system. According to the advisory, North Korean state-run organizations have used cyber attacks to target U.S. and international financial institutions, critical infrastructure, government and military networks, private industry, and individuals. The advisory aims to notify the public about these threats and encourage the implementation of technical and behavioral measures to enhance protection against these threats, and also encourages increased communication between the private sector and relevant U.S. agencies such as Cybersecurity and Infrastructure Security Agency, or CISA, and the FBI Cyber Division with respect to such threats. Next slide. In addition, in the latter half of the year, OFAC, joined by the State Department's Bureau of International Security and Non-Proliferation, NBIS, issued a joint advisory putting the international community on notice as to various North Korean procurement entities and deceptive techniques employed in the operation and support of the regime's ballistic missile program. This advisory specifically points out the industries most at risk by North Korean procurement activities, and identify specifically the electronics, chemical, metals, and materials industries, as well as the financial, transportation, and logistics sectors. The advisory also identifies numerous types of products that are likely to be implicated and recommend additional compliance measures and know your customer policies and procedures to ensure compliance with these potential landmines. Next slide, please. Finally, in another joint advisory from the Department of Treasury, State, and the United States Coast Guard, the U.S. provided additional guidance to address illicit shipping and sanctions evasion practices with respect to North Korea. This advisory updates previous advisories issued and is targeted at the maritime, energy, and metal sectors, and intends to provide additional information and tools for the industry in the sector to counter illicit shipping and sanctions evasion. The advisory recommends several steps to minimize the risk arising from deceptive practices, which include institutionalizing sanctions compliance programs, establishing AID best practices and contractual requirements, monitoring ships throughout the entire transaction lifecycle, and exercising supply chain due diligence. Next slide, please. Finally, further escalating the risk associated with transactions involving North Korea, the United States also issued significant amendments to the North Korea sanctions regulations in 2020. These amendments implement additional secondary sanctions for certain transactions, add potential sanctions restrictions on the use of correspondent accounts for non-US financial institutions that have provided significant services to SDNs, and impose other changes. These changes are unlikely to be of significant economic impact given the small size of the North Korean economy, but they do demonstrate an increasing focus and intensification of US policy with respect to North Korea. So I think I'll stop here, and then I'll pass it back over to Mike for a discussion of US Venezuela sanctions.
Thanks very much. So we can talk a bit about Venezuela sanctions here. What's interesting about Venezuela is, when this program started, there was a lot of questions about, why of all the places in the world is the U.S. focused on Venezuela as opposed to any other either Latin American regime or global regime where there are, questions about democratic integrity, where there are sort of authoritarian governments, like why Venezuela? The answer is really twofold. The first is that for as long as there have been sanctions programs, as Peter noted, going back some 200 years, there's also been a pretty consistent doctrine in the United States that we care a great deal about what happens in the Western Hemisphere, particularly in circumstances where there are natural resources at stake, or where there's an influence from other global powers in what we would term to be, our backyard. See, for example, like a Cuba program. Venezuela, being more recent, though, has another element to it, which is, in addition to being focused on democracy, in addition to being focused on, restricting access to by sort of malign actors to intensive natural resources. When you look at the economic activity of the country of Venezuela, and you look at the countries and governments and commercial players that are most deeply involved in the Venezuelan economy, particularly in the oil and natural gas sector, what you find is that most of the firms involved in those commercial activities are not U.S. firms, with the exception of Chevron. Most of the oil reserves, most of the economic activity in Venezuela is Russian and Chinese companies. And so this one, as with many other things, you sort of get a twofer. You get to talk about human rights, you get to talk about democratic institutions and rule of law, and you also get to try to influence the conduct on a global geopolitical scale of, two of the other major commercial powers in the globe, Russia and China. So what we've seen is more than 100 individuals sanctioned under the Venezuela program. We've seen an expansion of the scope over time of the Venezuela sanctions program, starting initially with financial restrictions and then moving more broadly to entire sectoral restrictions around virtually all aspects of the Venezuelan government, including the oil and natural gas sector, and a gradual tightening of the restrictions even in that sector over the last couple of years. And then we've seen something that is, we've talked about this a bit in today's overall session, is the use of a material support provision to really discourage international players, non-US companies, from providing support to the Venezuelan economy or to the Maduro government, even in circumstances where they are not themselves directly subject to US law. So next slide. We'll talk a bit about sort of the more recent developments. One is designation of the entire government of Venezuela and all of its entities, instrumentalities under Executive Order 13884. This was a substantial expansion of the earlier designation of PDVSA, which is the National Oil Company of Venezuela, which had occurred under Executive Order 13850. But in addition, there were a number of more specific or indeed enhanced sanctions targeting the Maduro regime over the last 12 to 18 months, including the blocking of PDVSA and its subsidiaries, limitations on dealing in government of Venezuelan bonds, which were a source of revenue to the government. Specific blocking sanctions against the sort of Venezuelan central bank, as well as Bandas, which is essentially a not government owned, but government influenced bank. And then a set of sanctions that targeted potential sources of support for the Maduro regime. So the first of these occurring in March of 2019 against, unsurprisingly, a Russian financial institution that provided services almost exclusively to Maduro government officials. Designations of the shipping companies and related vessels involved in shipping oil from Venezuela to Cuba. Again, targeting two sanctions programs with one fell swoop. But most of the shipping companies that were involved in that enterprise were either Venezuelan, Cuban, or in certain circumstances, Chinese and Russian shipping companies. The designation of Rosneft Trading in February and March of this year, that was a further ratcheting up of the sanctions against PDVSA. Up until the point that Rosneft was designated, there were still a significant amount of oil swaps related trading efforts to sort of create a market for Venezuelan crude, even though that market was under sanction. Rosneft Trading also illustrates an important feature of US sanctions programs, which is sometimes they target just the bad actor and don't go upstream. Interestingly, OFAC could have targeted Rosneft more broadly, right? But they elected to target only the trading arm, to really refine the sanctions, to target them specifically at the malign conduct at issue, and not try to get into a situation where they were blocking really one of the largest integrated oil companies in the world. They went at the real sort of significant trading arm. And most recently, as mentioned in the China and Hong Kong section, the China National Electronic Import-Export Company, CNESC, was also designated for its activities in Venezuela specifically, but is, as noted, sort of part of the broader strategy and foreign policy related to sanctions and export controls related to China. Next slide. So in terms of where this is headed and things that may still be on the horizon, Executive Order 13850, which was the precursor to the designation of the entire government of Venezuela, authorized sanctions against companies that were operating in the Venezuelan gold sector, as well as any other sector of the Venezuelan economy. No designations have been made beyond the sort of earlier ones related to PDVSA, but it's important to recognize that these authorities are still on the books until they are either rescinded or changed or superseded. And so, as foreign policy evolves toward Venezuela, as the U.S. reaches a determination about how it will or whether it will continue to support the Guaido government or the Guaido administration, these authorities remain on the books, and in particular, the material support provisions in both Executive Order 13850 and 13884 can still be interpreted broadly. The difference between the material support provision and some of the secondary sanctions measures and menu-based sanctions measures that we've discussed is that there is no lesser alternative available to OFAC under these two executive orders other than designating foreign firms as SDNs themselves. So unlike the circumstances we discussed under CAUTSA, and for example, the use of a menu-based approach to the Turkish defense industry, in this case, if there's a company or entity or individual that remains very active in Venezuela in sectors that are subject to sanction, the only option available to OFAC is to designate the entity as an SDN. There's no menu-based authority available. So it is a very kind of blunt instrument in terms of advancing US foreign policy objectives. And as Peter talked about in sort of the early introduction, sometimes that means that less will happen because you don't have the option to do anything other than the most severe penalty available. So it remains to be seen how this is going to be deployed as we go forward. But just a note that unlike other aspects of sanctions that we've talked about today, there's not likely to be a warning or a lesser sanction than just pure designation in the Venezuela context. In addition, OFAC hasn't really been helpful in providing a lot of formal guidance about its licensing criteria or policies related to ongoing commercial activities in Venezuela. But informally, they have been engaged in a dialogue, especially for firms that, generally speaking, are good actors and are minority owners in commercial businesses in Venezuela. There is an open door policy to allow for those dialogue to occur, but OFAC has not really undertaken a comprehensive effort to consolidate those questions or provide a lot of insight into the sort of next steps for the Venezuela program. So with that, I think we can turn this back with one more slide. These are just sort of important factors about where this goes. Next slide, please. This is sort of a basic summary of what happens. Oh, we need to go back one. Sorry, Brian, my bad. This is just sort of a basic summary of what has been designated under the Venezuela program. Just a reminder that the government of Venezuela is literally every aspect of the Venezuelan government. Any sub-agencies, any government-controlled companies, of which there are many, and that as a consequence of this broad and sweeping designation, OFAC has had to issue more than 24 general licenses to allow for certain commercial activities to occur. And over time, as government officials, both within and without Venezuela, have sort of shifted their allegiance from Maduro to Guaido, those individuals have been removed from the SDN list. Again, sort of demonstrating from a policy perspective, that the SDN list is intended to change behavior, and when that behavior indeed does change, that the advancement of designation removals tends to accelerate. The last piece here is that the licensing and general licensing, all of these provisions require a lot of wind down, primarily because the goal of these sanctions, again, being to change behavior, is to not penalize any U.S. companies that may still be involved with these firms in Venezuela and allow them time to exit. Also, the material support provisions being as severe as they are means that there should be some type of wind down in all of these instances, because it's critical to give even foreign firms an opportunity to decide what their risk tolerance is. And so this is a space that continues to evolve, continues to change, and suspect it will do so even well into 2021. So now we can continue to remain in the Western Hemisphere and turn it back to Peter to talk about Cuba.
Actually, unless Peter wants to talk about Cuba, I had it on my
it's you.
Chart to talk.
Excellent.
I'm happy to let Peter talk about it, though, since he did such a he kind of gave a nice preview during the opening. But Peter, I'm assuming that the plan is still for me to do it.
Yes,
Okay.
Please go ahead, Jason.
That's fine. I just wanted to make sure I wasn't missing anything. So, thank you, Mike, for giving me at least plausible deniability if I screw this up. It was Peter's fault. So rather than really getting into a lot of the details of what the Cuba sanctions program prohibits, I actually thought it would be interesting to talk about some of the odd aspects of the Cuba program in comparison to some of the other sanctions programs, and some of the where it sits in terms of the where it sits sort of in relation to the other sanctions programs, and some of the concepts that exist in other sanctions programs, and then with a brief discussion of sort of where things might go with respect to Cuba under the Biden administration. So the Cuba program is our second oldest existing sanctions program, after North Korea. It started either in 1960 or 1958, depending on whether you consider an arms embargo against the regime that Castro deposed to be the beginning of the sanctions program. But essentially, it's always, as it exists now, it's always been a reaction to the revolution that happened in 1959, 1960, and the Castro and successive regimes under our undying opposition to communism in the Western Hemisphere. The goal, as with other sanctions programs, has been explicitly been regime change, and as you can tell, it's going really great. I mean, we've really made some excellent progress in achieving that goal. It's just about to pay off. Seriously, it's kind of become a bit of an entrenched program. Obviously, it's not really going anywhere, but at the same time, unlike some of the other programs we've talked about, Cuba is not a world player in the sense of Russia or North Korea or Iran, and certainly does not present the same sort of national security types of threats as those countries. And as a result, a lot of the provisions of the Cuba sanctions program have gone largely unchanged. There was an effort to relax the sanctions during the Obama administration. And again, just like many things that happened in the Obama administration, the Trump administration set out to undo those things and has undone a lot of them, but not quite to the extent as in the Iran program. A peculiar aspect of the Cuba program is one about jurisdiction and terminology. So we've talked about a lot about U.S. persons and application of sanctions prohibitions to U.S. persons. The term used in the Cuba sanctions program is persons subject to U.S. jurisdiction, which is not only a different term, but it means something else. It means it includes U.S. persons. It includes any individual wherever located who is a citizen of, or resident of the United States, or any person within the U.S. or any company organized under U.S. laws. But it also includes any company owned or controlled by any of those persons, and therefore similar to, but not exactly like the Iran program, subsidiaries or owned or controlled entities by U.S. persons who are not themselves in the United States or organized in the United States are required to comply with Cuba sanctions. Other than that, foreign persons who are not subject to U.S. jurisdiction because they're not citizens, residents, or in the United States, and not subsidiaries of such persons, there are few restrictions. One of the reasons for that stems from the fact that unlike many of the other sanctions programs that we've talked about, our Cuba sanctions program is unilateral. And as a result, it is a real sticking point with a lot of our allies, including Canada, UN, the EU, and UK. So there are not secondary sanctions under the Cuba program like there are under some other programs. Other countries and nationals of other countries are largely free to pursue commercial or other opportunities in or with Cuba. The real challenge comes again from whether those transactions are going to somehow implicate or involve the United States, either because they involve U.S. origin goods, services, or technology, which can't be provided by any person. Financial transactions that might involve the United States, including dollar-denominated transactions that would require processing by a U.S. bank. So those are, it's not that the Cuba sanctions program is not an issue for non-U.S. persons. It's just an issue in a really different way than some of the other sanctions programs. But in a way that shares common features with those programs. These ideas of causing a U.S. person to violate the sanctions, or causing a U.S. person to engage in a prohibited transaction, or engaging in a transaction involving U.S. origin goods, services, or technology, are very much common themes throughout these programs. Another sort of peculiar aspect of the Cuba program, and this is something that's kind of been relaxed a little to a certain extent, but under the Cuba sanctions program, all Cuban nationals are considered blocked just because they're Cuban nationals. So that means that a person who is a citizen or subject of Cuba, who's been domiciled or permanently resided there, is considered blocked for purposes of Cuba sanctions, again, as to U.S. persons, or persons subject to U.S. jurisdiction, unless that person becomes unblocked by residing permanently somewhere else. Now, this can create significant compliance issues by persons subject to U.S. jurisdiction, because there can be there's now a general license on certain transactions with individuals who are Cuban nationals, but in commercial dealings, there can be challenges in sort of identifying when a person is a blocked Cuban national, or when an entity is a blocked Cuban national, and that general license, it's sort of alluded to in this chart where it talks about Obama-era relaxations of sanctions. There are still restrictions on indirectly providing goods or services to Cuba. So, for instance, dealings with individuals who are blocked Cuban nationals in a third country are authorized, but only where it's limited to just that transaction with that individual person, and it's not sort of an instance of services or goods going back to Cuba in connection with it. So that can present some compliance challenges for persons subject to U.S. jurisdiction. And another sort of aspect of our Cuba sanctions program, as it exists outside the United States in the international space, are the significant array of blocking statutes in other countries and jurisdictions that actually make it illegal to comply with Cuba sanctions. It can be very challenging for persons who are not U.S. persons because they are foreign corporations, but nevertheless are subject to U.S. jurisdiction and required to comply with U.S. sanctions against Cuba, but at the same time are subject to blocking statutes that create potential legal exposure for them if they do comply with these sanctions. The next slide, please. So just a quick note on sort of some of the developments in Cuba sanctions over the last few years and where we might be headed. Like I said, the Trump administration quickly set out to undo the progress that had been made under the Obama administration with respect to Cuba. The Obama era sanctions relaxations were really aimed at, I think, sort of encouraging Cuba to become more integrated, more closer to the United States commercially. A lot of these things, a lot of the relaxations had to do with expanded ability to export goods or services to Cuba, but a lot of them had to do with travel. And a number of Americans took advantage of the general licenses that were issued to permit travel to Cuba. This was shut down or scaled back shortly after the beginning of the Trump administration. And it's sort of, the Trump administration has sort of continued to scale those back, including quite recently, until a couple of months ago, you could buy Cuban alcohol and tobacco in a third country and bring it back and impress your friends with your Havana Club rum or whatever. And that was recently excluded from the scope of that general license. Again, probably not a very popular move, but certainly one that was intended to increase, to cut off a source of revenue potentially for the Cuban government. Another aspect of our Cuba sanctions program, which isn't exactly a sanctions program, is the entry into force of Title III of the Helms-Burton Act, which permits U.S. persons to sue any person who traffics in property that was confiscated. Trafficking, so the Helms-Burton Act was passed in, I think, 1996, but it was dormant. Title III of the Helms-Burton Act was dormant through waivers since then. Title III is the provision of the Helms-Burton Act that contains this private right of action for trafficking in confiscated property. Those waivers were allowed to lapse in 2019, and as a result, plaintiffs have brought Helms-Burton lawsuits against U.S. and international companies in a wide range of sectors. It's affected tourism, oil and gas, property development, shipping, banking and finance. And these cases allege that the defendants, by maintaining these businesses in Cuba, essentially have trafficked in confiscated property, trafficking being defined as knowingly and intentionally taking various actions with respect to confiscated property, including engaging in a commercial activity, using or otherwise benefiting from confiscated property. So on its face, it's very broad. Around 30 lawsuits have been filed. And so that's been sort of a more recent development in our Cuba sanctions program. Although again, it's not. It's the idea is to reallocate, return the funds that are believed to be wrongfully taken, and to put economic pressure on, I guess not just the government of Cuba, but also any sort of economic actor in Cuba. So in terms of where things might be going with the change in administration, there's generally been sort of a belief that change is likely to be relatively slow. I didn't mention this at the outset, but the Cuba sanctions program is a very politically sensitive program, particularly in South Florida, which has a large population of Cuban Americans, many of whom themselves either fled Cuba in the 60s or are descended from people who did. So it's a pretty emotional issue. It's politically sensitive. There's a sense that the Biden administration could restore some of the general licenses. The ones that I've seen as being identified as most likely are for remittances and air travel. But I think it's generally considered unlikely that there's going to be a return to the Obama administration level of permissiveness with regard to travel. Another issue that I skipped over is the issuance of a Cuba restricted list. This is a new thing, a newish thing that's occurred under the Trump administration, and it identifies entities in Cuba that are off limits essentially under general licenses. So while some of the general licenses that were issued under the Obama administration have been maintained, there's now this category of entities where a transaction that occurs under a general license can't involve those entities. That seems likely to persist to me. The distinction between certain entities in Cuba that are okay to deal with under a general license and other entities that are not okay to deal with under a general license. So the entities on the list might change, but I think that's probably likely to remain. And then, sort of complicating things is this, you've probably read about, there's a number of embassy workers suffer from a mysterious illness, and nobody really knows what caused it or who did it, but that's certain to be an issue that is probably going to need to be resolved before we see much further relaxation under a Biden administration. And with that, I am going to turn it over to the real Peter, who's going to talk about the global Magnitsky sanctions.
Well, thank you very much, Jason. Next slide, please. The Global Magnitsky Sanctions Program was created in 2016, and it takes its name from Sergei Magnitsky, a tax lawyer who died in a Russian prison after investigating a tax fraud case. And Magnitsky's cause was taken up by Bill Browder and has ultimately resulted in 2 statutes in the United States. The first is from 2012, and this is the Sergei Magnitsky Rule of Law Accountability Act. And that law provides for sanctions on people involved in the case of Mr. Magnitsky. I'm not going to focus on that law today. Instead, I'm going to focus on the second law, the 2016 Global Magnitsky Human Rights Accountability Act. So to add to the complexity of US sanctions law, we actually have 2 Magnitsky sanctions, and they each cover a different scope. But Global Magnitsky, or GLOMAG as it's come to be called, is a relatively new tool that gives the US authorities more options to penalize and try to deter human rights abuses and corruption around the world. And unlike other sanctions programs that we've talked about today, GLOMAG is not tied to any particular country or geography. So over the last little while, we've talked about China, we've talked about Russia, we've talked about Cuba, we've talked about Venezuela. I'm going to talk now about a sanctions authority that is agnostic as to jurisdiction. Unlike some of these other sanctions programs as well, GLOMAG gives a statutory voice to NGOs. This is a really unique feature of GLOMAG. It also gives a special statutory voice to certain congressional committees, the Senate Banking Committee and Foreign Relations Committee, and its counterparts in the House Financial Services and House Foreign Affairs Committees. And it provides a special statutory mechanism for NGOs and for those two committees to provide information to the executive branch, to the administration, about people and entities that may be worthy of being sanctioned or may be eligible to be sanctioned under the GLOMAG authority. And what's particularly interesting about this statutory mechanism is the pride of place it gives to NGOs. We don't see this in other sanctions programs. And about the pride of place it gives to those four congressional committees, Senate Banking and Foreign Relations and House Financial Services and Foreign Affairs. And in the case of the congressional committees, what's even more interesting than the special shout out they get is that there's actually a statutory mechanism that requires the president to consider information that those committees provide and make a determination about the information that's presented to him or her. When it comes to sanctions, as we've talked about throughout the day, there is typically a tremendous amount of discretion that the executive branch holds. And what we've seen over time is Congress try to cabin that discretion by imposing sanctions programs, by trying to force the executive branch's hand to administer programs in one way or another. And consistently, administrations have pushed back on that. And this tool within GLOMAG is a pushback at the pushback. It's an attempt to try to make, as a matter of law, Congress's view count and make information provided by Congress heard and considered. Now, for purposes of GLOMAG, we're talking about human rights abuses and corruption. And human rights, for these purposes, has a definition. It's defined as people who are responsible for things like extrajudicial killings and torture and other gross violations of internationally recognized human rights. And it's when that type of conduct occurs against people who are working to expose legal activities of government officials or to promote human rights and freedoms, including rights to a fair trial and democratic elections. So human rights abuses, human rights are certainly terms that have a sort of meaning in the vernacular, but for purposes of GLOMAG, they have a defined meaning. The same goes for corruption. Here, for purposes of GLOMAG, corruption means a foreign government official who's responsible for acts of significant corruption, or someone who is associated with that official or who facilitates the corruption. And here, corrupt acts can include things like expropriating private assets or public assets for personal gain, corruption in government contracts or in the extraction of natural resources, as well as things that are sort of more traditionally thought of as corruption, like bribery and sheltering the proceeds of crime and ill-gotten gains. Now, what makes GLOMAG unique, again, when it comes to corruption, is that the US already has laws that prohibit foreign corruption. The Foreign Corrupt Practices Act, or the FCPA, is certainly among the most well-known of statutes in the US and around the world when it comes to anti-bribery efforts. But GLOMAG adds a really special capability here, a special tool to the anti-corruption toolkit. That's because GLOMAG, unlike the FCPA, is implemented by administrative action. No judge, no court is required. And GLOMAG can be used to target both the bribe giver, like the FCPA, but GLOMAG can also be used to target the bribe receiver, unlike the FCPA. So GLOMAG adds a set of complementary features, complementary tools to the anti-corruption toolkit. Next slide, please. So GLOMAG has its home in a statute from 2016, but was then implemented by Executive Order 13818, issued by President Trump almost a year ago, or almost 3 years ago, on December 20, 2017. And here, the executive order that implements the GLOMAG statute actually expands on the statute and builds on it. And while the statute targets gross human rights violations and significant corruption, the executive order doesn't use these qualifiers. So the executive order doesn't just target gross human rights violations. It refers to serious human rights abuse. It doesn't define the term, but a fair reading of it, I think, is that a serious human rights abuse would certainly encompass a gross human rights violation, but not be limited to it. Similarly, whereas the GLOMAG statute refers to significant corruption, the executive order refers just to corruption. Again, the executive order, by its plain meaning, by the plain English, would seem to be more expansive and build upon the statute. The executive order also functionally delegates the administration of GLOMAG to the Secretary of the Treasury. Now, as of yesterday, when we had to submit the slides, there are at least a few hundred GLOMAG designations. The reason why I say at least actually comes back to something I mentioned earlier today, and that Mike and Jason and Sharzad have noted throughout, which is the 50% rule. As a reminder, this is the rule that operates automatically and by which OFAC says any entity that's owned 50% or more, directly or indirectly, in the aggregate, by a sanctioned person is itself considered sanctioned. So it's very likely that there may be entities out there which are sanctioned under GLOMAG, even though those entities themselves are not on the SDN list. The range of GLOMAG targets is incredibly large and diverse. And it spans geographies, it spans public and private sector, it spans industries, everything from Cambodian military officers to Russian government officials to Saudi diplomats and Chinese officials, Nicaraguan police officers, private businessmen who work in Central and Southern Africa, and as I mentioned before, the entities that they control or that act on their behalf. Interestingly, there are a couple of countries that actually have 5 or more individuals designated under GLOMAG: Saudi, Uganda, Serbia, Burma, Iraq, South Sudan, China, and Cambodia. So again, you can see the incredibly diverse geographies, the incredibly diverse set of GLOMAG targets. And as a parting thought, I want to pick up on a point Jason made when he was talking about Cuba. Jason very rightly observed that the US embargo on Cuba is longstanding and is increasingly unilateral, which is to say that it is a US embargo on Cuba. It is not a transatlantic embargo, it is not a NATO embargo, it is not an EU embargo, it's certainly not a UN embargo. It is a US embargo. GLOMAG, on the other hand, is increasingly a multilateral effort. And what we've seen, and I'm sure that our partners tomorrow will discuss this in some detail, is that the idea of imposing sanctions, asset freezes, visa bans on human rights abusers and people who are engaged in corruption is not an idea that's limited to the United States. And what we've seen is that jurisdictions around the world, including in Europe, but not limited to Europe, have been looking to adopt their own version of GLOMAG to impose substantially similar sanctions regimes in their own jurisdictions. So unlike Cuba, which is a US only product, GLOMAG is increasingly international. With that, let me turn it back over to Mike as our MC, and I think we'd be happy to take any questions in the time that remains.
Well, it has been a pleasure to be with all of you today. Very much appreciate the questions we did receive. We covered some of them in the course of the presentation, but would like to open it up now for those of you who are on the line and wish to file a question with our team. We have just a few moments left. I would like again to thank ILI for allowing us to partner with them to put this presentation together. This is one of two. Tomorrow we will be covering EU and UK sanctions in the same format with a bit of a comparison of how the US, EU, and UK programs differ. But let me open it up for questions now over the chat and see if there are any topics we can further explore.
This is Robert Sargent. There's two questions that were asked in the chat. I'll read them if I can. How do you interpret the latest set of sanctions against PDI of Turkey?
Sure. So, you know, that sanctions program, we talked a bit about it in the Russian context because it actually occurs under CATSA. The interpretation there is that this is an ongoing sort of dispute over the S-400 system that's been in place for some time between the U.S. and Turkey. And, you know, Turkey remains sort of a challenging diplomatic endeavor for the U.S. under any U.S. administration. So what will be interesting to see going forward is how long these sanctions remain in force. They did use a menu of 5 out of the 12 CATSA sanctions. Some of them, primarily the ones in the export control arena, being the most meaningful, most impactful. But again, as with sanctions programs generally, if behavior changes or if diplomatic or commercial circumstances change, these sanctions can be easily removed. So I think it remains to be seen how the incoming administration is going to handle U.S.-Turkish relations. It remains a challenging one, as I mentioned, because of the fact that Turkey is both a NATO ally and also a purchaser of Russian military equipment. Not an easy place to be if you're the Turkish government, not an easy place to be if you are a company operating in the Turkish defense sector, but certainly one that requires a lot of attention to these changing dynamics.
Yeah, I thought it was. I thought it was interesting that the context of those sanctions are that the Congress is poised to pass the NDAA containing a provision that would essentially make the determination that that the sale of the S-400 system was a significant transaction and essentially compel the whatever administration was around after that law is enacted to impose these sanctions. And so there's some talk about whether this was sort of like a game of chicken where the Trump administration flinched. I thought it was interesting that I think CATSA 231 requires five of the menu-based sanctions to be imposed, and by my count, they imposed 4 against the entity and either 5 against 3 individuals affiliated with the entity, or a number of individuals affiliated with the entity, or maybe just the blocking sanctions against those people. So, it's interesting. It doesn't seem to me like it was like a real exact application of the statutory of the way that Congress kind of intended those sanctions to work. And it's kind of similar to sort of the way the Trump administration, I guess, approached sort of the chem bio sanctions against Russia by kind of like really trying to sort of soft shoe around imposing the most restrictive sanctions and the most damaging sanctions that on the face of the law it would be required to do. I mean, imposing blocking sanctions against an arm of the Turkish government would be I mean, they've kind of done it, as Peter said, they've done it briefly before, but it would be a pretty significant move. But it is challenging, and I think this is maybe a little bit off topic, I guess, but I think the challenge with a lot of these sanctions programs is when Congress mandates that certain sanctions be imposed in certain circumstances, it becomes really it creates real issues for administrations. Sanctions are supposed to be nimble tools and discretionary tools of foreign policy, which are supposed to reside with the executive. But this is like another instance where in the past, during this past administration, which is now coming to an end, there was clearly a lack of confidence in its ability to do those things. And so you had a situation where Congress was sort of requiring certain activity. And I guess I'm kind of hopeful from like a policy and good governance standpoint that doesn't really become the norm, because I think it just becomes really difficult for OFAC and the State Department to do their jobs when they have to do certain things under a statute. Was there another question, Robert?
I don't think so.
No, I don't.
I think we've covered them. But again, as we sort of wrap up for the day, thank you all very much for joining us. Hopefully, you'll join us tomorrow for the EU and UK portion. But until then, it's Mike Zolans from Washington signing off on behalf of Dentons, along with Peter and Jason and Sharzad. It's been our pleasure to be with you this morning. Have a great day.
Bye, everybody.
Hi, everyone. Thank you.